Good morning. We'll call this hearing to order. A couple of housekeeping things I want to go through. When we have someone, especially all you lawyers, come to the mic, I want you to, every time you come up, please state your name and who you're with for ETB and for our court report. Not on yet. Now I'm coming on. Okay. Reminds me of a Wolf concert in 1969, wasn't it? Yeah, I was gonna. Last time I had that much squealing in my ear. Well, maybe not the last time. Okay. Get back to that. I want everybody to state your name for the court reporter and so we can properly identify you on the live stream. Also, I want to remind everyone, we are limited with facilities, so there are restrooms upstairs as well as out here in the hall. And I've been asked to tell everyone when we're going to break for lunch. I don't really know, but we're going to try to hit it around noon, somewhere around there. So just to, it sort of depends on where we are in the proceedings. I'm going to turn it over to our hearing officer, Mr. David Butler.
Thank you, Mr. Chairman, very much. There were a couple of items from yesterday that I felt needed to be addressed specifically by me. I had looked back and reviewed order number 2018-161H, and it discussed a couple of the things that came up yesterday. Let's start with Mr. Giles' motion that all matters be made public in this hearing at the present time. That was a subject of a portion of the ruling, and I believe this is reasonable to address that motion at this time. And I'll just quote my paragraph, and it's the first full paragraph on the second page of the directive. I said, there are numerous items that appear to be designated confidential for unknown reasons. The proceeding in this case need to occur in an orderly and expeditious manner, and the cooperation of the parties is sought in either voluntarily removing the confidential designations as much as possible or refraining from cross-examination on such areas if possible. If a party believes that the confidential designation should be removed from specific items or sections of specific items, please submit your request by the end of proceedings on Monday, November 5th, 2018. Also, if a party is willing to remove the confidential designation from any item or section of an item, please also notify this hearing officer by the close of proceedings on Monday, November 5th, 2018. And with the permission of the chairman, I would like to direct this as an answer to the motion of Mr. Giles at this time, subject to change at a later date if necessary, but I believe at this point the November 5th close of business is a reasonable deadline for parties to do what they see fit in the area of confidential information. The other item I wanted to address had to do with the situation with witnesses Brown and Walker. And again, I'm going to quote a section of my directive on 2018-161H. And I said at that point, with the approval of the chairman, ORS may present the testimony of Ken Brown and Carlette Walker as pre-file witnesses during these proceedings in the manner described in the ORS letter of October 30th, 2018, i.e. the witnesses will adopt their depositions as a pre-file testimony and be physically present to do so. The witnesses shall be subject to cross-examination by the parties and questions from the commissioners, just as any other pre-file witness would be. Although I agree that this is not the preferred methodology, it is reasonable and appropriate in light of the fact that witnesses do appear to possess firsthand knowledge of the facts and circumstances of many of the nuclear-related activities of SC&G under consideration in this case. And the fact that the witnesses will be physically present in the commission hearing room to address their deposition testimony rather than having their depositions read into the record by unknown persons. Further, an examination leads to the conclusion that the deposition should be released from the constraints of confidentiality, but I went ahead and qualified that to some degree at that time. The problem that I've got, and I think some of the commissioners may have too, is that we really never got a fully satisfactory explanation as to the absence of witnesses Brown and Walker. With regard to Mr. Brown, 2 days after the request that they appear in person, we get an explanation. We don't know where he is. You know, he works for FEMA. We think he's somewhere out there working for FEMA. And this is 2 days after they had asked this commission permission to bring him in. I find it, you know, a bit difficult to understand. And with Ms. Walker, we get basically a stipulation that says, well, you know, we think she's unavailable, and here's the information. 180-degree turn from what was presented to this commission 2 days before. Again, I don't believe that the explanation given was satisfactory. I don't really want to hear oral argument on it. With the permission of the commission, I'd just like to ask that Office of Regulatory staff perhaps brief this matter and serve it on the parties, and then, you know, we can take a look at that. But I think really further explanation of that particular situation is needed, because what I heard yesterday just wasn't very clear, and I'm not sure that it explained the whole story. So with that, Mr. Chairman, I thank you very much and would turn the matter back over to you.
Okay, thank you. Also, I think we have our representative from Transcontinental Gas Pipeline Company here today, so we'll take your appearance and get a microphone so people can hear you. Somebody hand him one of those mics.
Thank you, Mr. Chairman. My name is Jeff Griffith. I represent Transcontinental Pipeline, and I apologize for not being here yesterday. We have a very limited role in these proceedings, and we have, as you know, a settlement agreement pending for commission approval. So,
thank you.
Happy to be here today.
Okay, any other preliminary matters that we need to do before we continue? He was first, then he stood first.
Good morning, Mr. Chairman. Thank you very much. David Balser of King & Spalding on behalf of SCE&G. Yesterday, in my opening statement, I made reference to requests for documents that SCE&G served upon ORS related to communications between ORS and the governor's office. In response to the information requests that we served in this matter, ORS objected to those requests for those communications and refused to provide to us any documents evidencing communications between ORS and the governor's office. We are scheduled to take Mr. Scott's deposition next week, and we would like to have those documents in advance of that deposition. I note that yesterday, apparently, a spokesman for the ORS is quoted in an article in the state newspaper. Mr. Aiken said that the agency isn't withholding anything and has turned the letters over to everyone who has asked for them. And the state newspaper says that it had obtained the letters months ago. So ORS is saying it has turned over the very letters that we've asked for to the newspaper, but has refused to provide them to us. And we ask that this commission order ORS to produce all responsive documents to the information request for communications between ORS and the governor's office no later than Monday morning, so that we will have them before we depose Mr. Scott.
Mr. Chairman, thank you very much for the opportunity to answer this. And SCE&G has received all of those letters. In fact, their witnesses have attached them as exhibits to their testimony. Mr. Petrunik in particular, they're the PERC letters that have gone to the Public Utilities Review Committee, which includes the governor's office. And those are the communications that have occurred with the governor's office. But we're happy to produce them again by Monday.
Thank you. Okay, let's get that worked out. Mr. Guile.
Mr. Chairman, try to avoid that, Mr. Chairman. I was at that same rock concert, I think.
There you go. You can't pull it closer to you, though, because you can't hear you at all now.
All right, can you hear me now?
Yep.
All right, good, thank you. I appreciate the hearing officer's efforts to try to resolve the confidentiality claims, which we did not assert, and I assume were asserted by SC&G, and I think that we have a long history of them asserting confidentiality in vastly overbroad fashions and then retreating from those claims on the eve of a hearing or on the eve of a dispute resolution. But I rise only now because November 5th simply is too far into this case for my clients to have a fair opportunity, not to mention the public, a fair opportunity to review evidence that's now being offered in evidence. At least two of the exhibits, and maybe more, to Mr. Jones's testimony, the ones that were offered yesterday, I understand from counsel were identified as remaining either redacted or confidential in whole or in part. And I think I'm early up today to cross-examine Mr. Jones, and so I simply can't review those documents since I've declined at my client's instruction to participate in treatment of confidential information. I can't cross-examine Mr. Jones or make an intelligent, informed decision about whether to cross-examine him on key documents reflecting on the imprudence of this project. And so with all due respect to David Butler's efforts, valiant efforts to resolve all these matters, I can only say that now the train has left the station and we are taking in evidence on which this commission and the public has a right to judge whether the company is wrongfully seeking recovery of charges for this abandoned project. And I just ask that at least with regard to measures that are being offered in evidence now, I ask the commission to resolve the question of whether they should be treated confidentially or not. In other words, should SC&G continue and persist in that claim? And if so, they have the burden of offering a rationale, lawful basis for sealing those documents from my clients and the public. And that's the point I rise on. Thank you.
Any response?
Mr. Chairman, David Balser on behalf of SCE&G. With respect to Mr. Jones, who is the witness before the commission now, we believe we have sufficiently resolved the issue that was before the commission when we broke yesterday with respect to confidentiality. So we do not anticipate that there'll be a problem with Mr. Jones, and we don't anticipate a problem with the other ORS witnesses that are scheduled today. There is one portion of Mr. Brown's deposition, which, if Mr. Brown appears, would be an issue.
They still can't hear you. You got these microphones. You were doing a good job a while ago. You got to speak into these things, y'all. Everybody's gotten timid today for some reason after my first little squawk. So, punch it. Got to get the red light. There you go.
Okay, can you hear me now?
Yes.
Not a Steppenwolf concert, not Born to Be Wild. We're here. Okay. The response that we have, Mr. Chairman, on this is, to Mr. Gild's point, we have resolved with the ORS, we believe this morning, the issue that was pending before the commission yesterday with respect to confidentiality. So we have agreed that the surrebuttal testimony and the summary that Mr. Jones provided can come into evidence. So I don't think there's going to be an issue with this witness. Of course, November 5th is Monday. We don't anticipate, so the designations in the schedule that Mr. Butler set out, I think, is an appropriate one because we really do not anticipate any issues of confidentiality to arise with respect to the scheduled witnesses for ORS today.
ORS.
If you don't mind, I would just like to address this next witness is going to be Anthony James, and part of his summary did contain a reference to some testimony of Mr. Ty Troutman, and so if what Mr. Balser is saying is true, we'll have an unredacted copy of Mr. James's summary.
Good morning, Mr. Chairman. I'm John Challey. I represent SCE&G. We have no claim as to the confidentiality of Ty Troutman's deposition. Ty Troutman is the president of Bechtel Power Corporation, and while I believe we checked the transcript this morning and don't see Mr. Troutman's lawyer having designated that transcript as confidential, my memory is that he did so at the conclusion of that. That's between, in this instance, that's between DORS and Mr. Troutman's lawyer, the lawyer for Bechtel, but we have no problem with that deposition coming in an unredacted form.
Thank you. Mr. Gile, you had stepped, and then I'll get.
And just to clarify, my notes from yesterday reflect two of the exhibits that were offered by ORS for Mr. Jones that appear to be numbers 3 and 9, if I got my notes correct, were the ones designated confidential. And if I understand SCE&G counsel's representations now, there are no further claims as to confidentiality for those two exhibits. And if so, that's clear, and I'd like to just establish then I have access to that information.
That's not quite clear, as we just said. Exhibit number 9 to Gary Jones's deposition is the draft transcript of Ty Trout. That's the Bechtel Power Corporation claim of confidentiality. So that has to be resolved with Bechtel Power Corporation. Exhibit 3 is the transcript of Ken Brown. As we talked about, there are 3 specific page and line designations as to which we do maintain a claim of confidentiality.
Thank you. That helps.
Mr. Kaufman.
Yes, John Kaufman representing AARP. We are in the same position as Mr. Guile, and I would join in Mr. Gile's request that that the commission, err on the side of transparency and disclosure. And I just was trying to clarify if there has been some removal of confidential designations. I'd like to know when are we going to see the new public versions of those? Will the other parties get a copy of the I'm not in the loop as to what the agreement has been, or
I'm gonna let
seen the new
Mr.
document.
Butler.
Okay, it sounds like, some designations have been removed, but maybe the matters haven't been filed in their unredacted form. Would ORS or SCE&G please furnish this new information to these parties? Is that doable?
We'd like to see it before we proceed, if possible.
Yeah, that would be extremely helpful. Let's see.
We're happy. As I said, the parties sitting here today can't resolve the question about Exhibit 9 because that's a claim of confidentiality by a third party to this proceeding. If it gets resolved, we're happy to provide the other participants in the proceeding with a copy of Ty Troutman's deposition transcript. As to the copy of Ken Brown's deposition transcript, we can apply the redactions to the very few number of portions of that transcript as to which we maintain a claim of confidentiality. I don't have that with me today. It would take us a few hours at least to do so. We're happy to do that, though.
Okay. We're gonna take about 15 minutes and let y'all talk among yourselves. We're gonna leave, come back, and I'd like for some of this to get worked out because this is bogging down the process. Recess for 15 minutes.
We got to wait for the, okay, now.
Sorry about that.
Sure. Thank you, Mr. Chairman. Two things I wanted to point out, and, you know, enough is enough on this Brown and Troutman stuff. Okay, let me quote a little bit more from the hearing officer's directive. We're going to give the parties a chance to work things out, but since that may or may not have happened, let me reiterate something that we said yesterday. And we were talking indeed about the confidential designations of a number of things, but Brown and Walker specifically. We said if a party believes a confidential designation should be removed from specific items or sections of specific items, submit your request by Monday. But in pertinent part, we said in terms of Brown and Walker, should SCE&G or any party disagree with a conclusion that the deposition should be released from the constraints of confidentiality and should be public information, should any party disagree with that conclusion by the hearing officer, said party shall submit a page and line designation with oral argument on why they believe certain matters in the two depositions should retain confidentiality by 12 noon Thursday, November 1st, 2018. Nothing was received. Therefore, it's my opinion that the confidentiality matters with Mr. Brown's deposition, as well as Ms. Walker's, were waived for failure to abide by the designation ruling. The other thing with the Troutman deposition that was raised and the raising of some Bechtel privilege or some issue by Bechtel counsel, I don't see a Bechtel attorney here to defend that or to discuss it. Therefore, any confidentiality matter having to do with a Bechtel matter in the Troutman deposition is overruled. Therefore, those matters shall be public. Mr. Chairman. Yeah, so let's move on with Mr. Jones's work.
Okay, let's go for it now with Mr. Jones.
Thank you, Mr. Chairman. Again, Jim Cox from the White's Law Firm in Greenville, appearing on behalf of the South Carolina Office of Regulatory Staff. Your Honor, or Mr. Chairman, I'd just like to ensure that that the record is clear that the unredacted version of Mr. Jones's surrebuttal testimony has been adopted as though it was read into the record by the witness.
Okay, we need to, Mr. Jones's surrebuttal testimony will be, pre-file testimony will be entered into the record as if read orally from the stand.
Thank you, Mr. Chairman. And with respect to the exhibits attached to Mr. Jones's surrebuttal testimony, we would ask that the unredacted form of those exhibits be entered into the record as the next composite hearing exhibit.
Okay, Mr. Cox, we would note, I've got a note about Exhibit 16 being Mr. Jones's surrebuttal exhibits. Were those the redacted versions that we discussed yesterday? I would think.
That was our last entry, so we want to make...
Mr. Butler, I believe we did, and Mr. Chairman, I believe we did enter it as a composite hearing exhibit, and I understand from the hearing officer's rulings today that that exhibit is the unredacted version of those exhibits will be entered into the record as composite hearing exhibit 16.
Yes, sir, that would be correct. Let's do that, Mr. Chairman.
Okay. It'll be exhibit number 16. Okay.
Thank you, Mr. Chairman, Mr. Butler. Mr. Jones, before we get to any summary of your testimony today, would it be possible for you to describe for the commissioners some information about your qualifications and background?
Yes, thank you. Finally, good morning, Mr. Chairman and members of the Commission. Again, my name is Gary Jones. I have, at this stage of my life, the exact number is not pertinent, but let's say I have over 45 years of experience with nuclear power plants. 32 of those years were spent with Sergeant Lundy, a international architect, engineer, and consulting firm based in Chicago. And 16 of those 32 years were spent as an owner of the firm and a senior vice president of that firm. I have also spent 2.5 years at the International Atomic Energy Agency in Vienna as a safety engineer there. I've been a private consultant since 2009, and I began work with ORS on this project in August of 2011. Thank you.
Mr. Jones, do you have a summary of your pre-filed direct rebuttal and surrebuttal testimony in these matters?
Yes, I do.
Could you please provide that summary to the Commission?
Yes, thank you. And again, good morning. My testimony sets forth my findings and recommendations resulting from my examination of the prudency of the costs incurred by South Carolina Electric and Gas during the construction of the project until the time the abandonment decision was made on July 31st, 2017. Based upon my experience in monitoring the project and after my review of the documents made available during discovery, I have concluded that the project costs incurred after March 12, 2015, which is the date of the filing of SCE&G petition under Docket 2015-103-E, that these costs were imprudent and should be disallowed by the PSC as a basis for recovery due to the abandonment by SCE&G in this petition. The specific amount of this disallowance and the amount that ORS is recommending that SCE&G should be allowed to recover on the Base Load Review Act abandonment provisions are provided in the written direct testimony of ORS witness Mr. Lane Colon and will be addressed in his summary to be presented later. In addition to the revised rates increases granted under the Commission Orders number 215-712 and 216-758 associated with these imprudent cost increases and schedule changes, these should be immediately rolled back, and the collection by SCE&G should not only stop, but the amounts already collected for these revised rates increases should also be refunded or credited to the retail customers as soon as possible. The company's actions to withhold certain additional information identified during discovery resulted in the approval of revised project construction schedules and budget increases that would likely not have been approved had this information been properly disclosed to the PSC and ORS. This means that the evidence of record required by the statute to be provided by SCE&G was incomplete, omitted, and misleading. And SCE&G used deception and withheld material information to obtain PSC approval of erroneous schedules and cost estimates. In addition, I will also address the following related areas, and that is the prudency of the SCE&G decision to abandon the project, the prudency of the SCE&G's decision to monetize the Toshiba settlement in lieu of accepting the originally proposed long-term payout, the associated transmission system costs, the transfers of certain originally shared facilities and assets to VC Summer Unit 1, and lastly, whether SCE&G properly managed the project. I have attached, or I'm showing here, an abridged version of Exhibit GCJ2 from my testimony, and that exhibit is the large poster board that you see down below, which really was not conducive to present on a slide. So we've broken it down. It's been abridged to present key major project milestone and exhibits specifically referenced in my direct testimony. I request that you refer to this timeline, which will assist you in maintaining the proper time frame and sequence of events as I further explain the basis of my findings and recommendations. Please note that I do not plan to present each of these referenced exhibits as part of my summary. However, they can be readily found in my direct testimony and support the statements that I am including in my summary. There are two major findings that support the March 12, 2015 date as the basis for my recommendation. First of these is SCE&G's failure to disclose their intent to have an independent project assessment performed that would provide further insight into the project status, identify significant issues that were contributing to project delays, provide potential resolutions or mitigation strategies to address these project issues, and assess the project completion schedule. Even though discussions were held prior to the September 3rd, 2014 date, which is shown on the exhibit here.
Mr. Jones, if I could just interrupt for a minute, I wanted to point out for the commissioners that your Exhibit 2, the timeline that you're referring to, is tab 12 in the notebook that we provided to the commission earlier. Sorry, Mr. Jones.
Okay, thank you. So even though discussions were held prior to the September 3rd, 2014 date of the Kevin Marsh email to Lonnie Carter, this is the date that Mr. Marsh clearly agrees to have an independent assessment done on the project. And that's the date that is indicated on this slide. I should also mention that in this time frame, the revised schedule was received from the consortium, and the SCE&G estimated completion team, EAC team, which I'll be discussing later, was formed and began their work. We now move into the 2015 timeframe, which is the next slide. Mr. Marsh's decision to employ a independent assessment was followed by a January 28, 2015 meeting among SCE&G, Santee, Cooper, and Bechtel senior executives to discuss the scope and request a proposal from Bechtel. Bechtel submitted that proposal on February 5, 2015, which outlined their scope of work, which included the services of 10 Bechtel highly qualified and nuclear power plant experienced senior managers to perform an 8-week assessment, including a schedule review, at a cost of $1 million. Failure to disclose their plan to have this assessment performed constitutes withholding material information from the PSC and ORS, because this disclosure would more than likely have resulted in either a delay in the filing of the petition. We go back to the original decision to make the assessment, or a delay in the review of the SCE&G petition until this assessment was completed and the results were fully reviewed. I can categorically state that this would have been my recommendation. And based on my experience with ORS, I believe they would have followed my recommendation on this matter. From my review of additional information obtained through discovery, I conclude that the review of the Bechtel assessment would have resulted in a much different outcome than the existing 2015 settlement agreement, and may even have resulted in cancellation or abandonment of the project as uneconomic. I would have insisted that SCE&G compel the consortium to address the Bechtel schedule assessment and completion dates and defend the efficacy of the schedule which the consortium had presented to SCE&G and which SCE&G had filed in their March 12, 2015 petition. The importance and impact of this failure to disclose cannot be overemphasized. Excuse me a second. The second in the series of SCE&G's ongoing deceptions that result in my decision to recommend the disallowance involves their intentional failure to disclose their complete lack of trust in the schedule and costs provided in their March 12, 2015 petition. It is important to note that the March 12, 2015 petition represented a significant departure from SCE&G's past practices of providing an adequate basis for schedule and cost changes. In previous submittals, changes to the completion dates had been supported by change orders to the EPC contract, and cost changes had been supported by executed or at least accepted change orders to the EPC contract. Neither of these practices was followed in the March 12, 2015 petition. ORS learned through our review that the EPC contract was not being revised to reflect the revised completion dates, and that many of the cost changes were based on unapproved estimates, many of which had no consortium input at all and were based solely on SCE&G input. ORS pointed out these unusual departures through the testimony of Mr. Anthony James in the 2015 hearing, but reluctantly accepted them because the BLRA provided no alternative at the time. Based on my review of additional information that came through discovery, it now appears that SCE&G's sole interest was to establish an unsubstantiated but plausible basis to obtain a rate increase. In my direct testimony and surrebuttal testimony, I have cited numerous examples of SCE&G's disdain and disbelief in the construction schedule that had been provided to them by the consortium and formed the basis of SCE&G's misleading March 12, 2015 petition. These examples cite statements made by SCE&G and Santee Cooper top executives, senior managers, and knowledgeable employees that reflect a complete loss of confidence in the ability of the consortium to produce or reliably meet a construction schedule. This lack of confidence was not conveyed to the PSC or ORS, but instead was masked as a general discussion about risks and improvements that needed to be made. Mitigation strategies and productivity increases in which SCE&G had absolutely no faith were characterized as expected and soon to be implemented improvements. Unfortunately, SCE&G was successful in deceiving me as well as the PSC and ORS. Their greatest deception at this time, however, involved their complete refutation and concealment of the cost estimate prepared by their own estimate at completion team. This team had developed an independent cost estimate of approximately $1.2 billion cost increase based on more realistic productivity factors and other more fact-based assumptions. This estimate was intentionally cast aside by senior SCE&G executives, and the decision made to proceed with the misleading March 12, 2015 petition based on the consortium's overly optimistic $698 million cost estimate. This decision was made over the strong protestations of Ms. Carlette Walker, the SCNG Vice President of Nuclear Finance Administration at that time, and a member, and I've later ascertained she was actually the leader of the EAC team. SCNG senior executives withheld this information from the PSC and ORS and provided false testimony to the PSC under Ms. Walker's name, according to her deposition. Ms. Walker's account is further substantiated by Mr. Kenneth Brown in his deposition. Mr. Brown worked in SCE&G's business and finance group at that time and was also a member of the EAC team. He adds that the EAC team results were presented to SCE&G executives on October 13, 2014, and that no action was taken to include SCE&G's own EAC team's recommendation in the March 12, 2015 filing. These findings have led me to conclude that SCE&G began their willful attempts to deceive and withhold materially important information from the PSC and ORS with the March 12, 2015 filing. The actions described here constitute imprudence and negate the previous rulings and require that all costs from that date forward be disallowed. Unfortunately, SCE&G's deceptions did not end with the March 12, 2015 petition. They continued and were compounded with the events of the third quarter of 2015 and subsequent filing of SCE&G's May 26, 2016 petition under Docket number 2016-223E, and continuing up through today, as I think has been well represented. On October 22, 2015, Bechtel presented the results of their $1 million, 2-month-long, 10-man senior management project team assessment to the senior executives of SCE&G and Santee Cooper. The most important aspect of that presentation was the Bechtel schedule assessment, which projected dates that were sobering, in the words of Mr. Lonnie Carter, CEO of Santee Cooper, and are represented on this slide. I present you a comparison from page 22 of my direct testimony, which compares the project completion dates that were included in the EPC contract amendment, which SCE&G approved only 5 days after this presentation. So that's the first designated as the WEC completion dates. The next are the projected Bechtel completion dates presented at the October 22nd, 2015 meeting. And that's designated as the Bechtel completion dates. And then lastly, the SCE&G independently developed completion dates that were developed by the SCE&G team after the Westinghouse bankruptcy. And I don't think it takes a real genius to figure out which ones were closer to the truth. If you look back at what WEC had developed in 2016. So it does not take an expert to see who painted a more realistic picture of project completion in October of 2015. I should also point out that the SCE&G dates were developed after almost 2 more years of subpar productivity. So that accounts in part for the even further extended dates that SCE&G developed. ORS was not aware of and had not been informed by SCE&G of the Bechtel assessment. We did not know the scope, the number of reviewers, the duration, the cost, or the result of the assessment. I first learned on or about October 15th, 2015, that some sort of assessment had been performed by Bechtel. An ORS colleague had attended the October 15, 2015 Plan of the Day meeting at the VC summer site, and at the end of the meeting, he observed an unknown gentleman thank the SCE&G staff for the support he had received during his assessment. Then he put on a Bechtel hard hat upon exiting the meeting. My colleague reported this to me and the other ORS team members, and this prompted me to add a question to the October 27th and 28th, 2015 agenda of the regular monthly construction status meeting to address the top 10 issues identified by Bechtel during the assessment. We had no additional knowledge of the assessment or results at that time. I was told by SCE&G in response that nothing new had been identified, that the assessment was done at a very high level, and the results were not known and by those in attendance, and that there was not and probably would not be a written report. We have subsequently learned through discovery that this information was false. The most misleading SCE&G statement was that nothing new had been found, despite Bechtel's schedule assessment, which provided projection completion dates that were 2 to 3 years beyond what was being discussed in the EPC amendment. SCE&G withheld this information from the PSC, the ORS, and the public until the projected completion dates were found in the draft Bechtel report and copies of the October 22nd, 2015 presentation during discovery. The entire Bechtel report was withheld by SCE&G well after abandonment until released by Santee Cooper under orders from the governor. The importance of withholding the Bechtel assessment, again, cannot be overstated. If the Bechtel projected completion dates had been known to me during my review of the May 22nd, 2016 petition, I would have insisted on a more detailed economic evaluation of the viability of continuing with the project. Even though the construction cost risk had been transferred to Westinghouse, other costs, for example, owner's cost, would still be increased due to delays in project completion dates. In addition, I would have recommended much stronger safeguards be added to the settlement agreement regarding the potential for a Westinghouse bankruptcy, because delays of the magnitude forecasted by the Bechtel projected completion dates would have greatly increased the losses to be incurred by Westinghouse and therefore greatly increased their risk of insolvency. SCE&G and their consultant have tried to disparage the Bechtel report as unimportant and useless and discredit the Bechtel schedule assessment. These attempts should not be allowed to stand. In my opinion, which is strongly bolstered by the testimony in the deposition of Mr. Ty Troutman, Bechtel executive in charge of the Bechtel assessment, SCE&G should not have ignored and suppressed the results of an assessment produced by one of the most prestigious and experienced nuclear power plant construction contractors in the world. It is not easily understood as to why SCE&G chose to utilize an untrusted, in their own words, and ill-performing, as demonstrated by the record, source, which was the consortium, to provide them with an unrealistic and unattainable completion schedule, and completely discounted it and ignored one of the top contractors in the nuclear business. In my testimony, I've provided numerous examples that came to light during discovery of the distrust and disdain that SC&G secretly professed against Westinghouse's ability to develop and meet a schedule. Yet they chose to file their May 12, 2016 petition using the Westinghouse schedule and continued to hide the Bechtel schedule. These acts in themselves clearly demonstrate a lack of prudence and a lack of project management expertise. The Bechtel report should have been embraced and acted upon as solid advice from an experienced and capable source, not ignored and hidden from the PSC and ORS. As an additional overt act of withholding material important information, SCE&G once again continued to mislead ORS in their response to Audit Information Request 1-32 dated March 24, 2016. SCE&G failed to list Bechtel when ORS requested a list of all consultants utilized on the project. Even when given a second chance to reply, they still refused to admit that Bechtel had served as a consultant on the project. SC&G continued until the bitter end to withhold and hide the Bechtel report. They did not make it available until forced to do so under orders from the PSC regarding discovery for this case. As a final commentary on the misguided and deceitful practices of SC&G in concealing the very important Bechtel assessment from the PSC and ORS, I call your attention to this slide, which highlights phrases cited in my testimony that were used to describe how SC&G handled the Bechtel report. It was scrubbed. It was whitewashed. It was flushed. I leave it to the Commission to determine whether these are words of a trustworthy regulated utility which has nothing to hide from its regulator. I will now address the contention of SC&G and their consultant that SC&G provided us with all the required and relevant information, and that I and the ORS should have known how this impacted the completion schedule. Simply stated, this is just another example of SC&G's ongoing efforts to mislead the Commission. My role and that of ORS is to monitor the ongoing construction activities and capital expenditures based on accurate, timely, and truthful information provided by SCE&G. ORS was tasked by the General Assembly with the responsibility, was not tasked by the General Assembly with the responsibility to develop construction schedules. We are to review schedules presented by SCE&G. Therefore, to state that ORS should have developed SCE&G's schedule is plainly erroneous. It should also be pointed out that knowing the issues associated with the construction of a project does not automatically enable you to divine the impact of the final completion date. The schedule of a nuclear power plant is very complex and comprised of thousands of interrelated and independent activities. To expect an individual, me, to determine the ultimate impact of a multitude of issues is just illogical. Pursuit of this path of attempting to shift the blame to ORS will not be a winning strategy for SCE&G. It is akin to SC&G adopting the position, "You should have known we were lying to you." As a final point, I have provided several reasons in my testimony as to why SCE&G should have been concerned about the project completion schedule, even though the construction cost risk had been primarily shifted to Westinghouse. I will not repeat those here, but I will mention one that was not directly called out in my testimony because I thought it was obvious. However, I should have stated that the settlement agreement required that SCE&G assume the cost of the project if Westinghouse or Toshiba failed to meet the provisions of the EPC contract. This requirement should have been enough to at least pique the interest of SCE&G management in having a reliable and accurate schedule. I believe that the SCE&G decision to abandon the project was prudent, and I'm just talking about the decision to abandon, not everything that came before that. And this is based on the information that I have seen thus far. The project was no longer economically viable. The risk had not been significantly diminished, and SCE&G maintains that they did not have the financial wherewithal to proceed on the project without a partner. I have seen no definitive evidence that supports the contention that the project should have been abandoned earlier, although ORS witness Mr. Norm Richardson indicates in his testimony that if Bechtel completion dates had been utilized in corrected analysis of Dr. Lynch's 2015 analysis, the project would have been uneconomic at that time. That doesn't necessarily mean that it would have been abandoned, however. Certainly, knowledge of the Bechtel schedule would likely have had an impact on continuing with the project, but there is no way to know because of SCE&G's ongoing deception and withholding this materially important information. I do reserve the right, however, to supplement or change my opinion based on additional information that may become available through ongoing discovery. SCE&G's decision to monetize the Toshiba settlement in lieu of accepting the long-term payout was prudent based on the economic conditions at the time. There was some uncertainty about the continued viability of Toshiba's ability to pay. ORS Mr. Lane Colon will provide additional details on this topic. Mr. Colon will address in his summary how ORS recommends that the transmission assets associated with this project be allocated. I partially agree with SCE&G's recommendation regarding the transfers of certain originally shared facilities and assets to VC Summer Unit 1. I provided my recommendations, and ORS developed an alternate approach which will be addressed in a later rates case. Mr. Colon provides some additional detail in his summary testimony. Based on my review of the additional information made available during discovery, I have come to the conclusion that SCE&G did not properly manage this project. Their decisions to withhold and mislead the regulatory agencies play a significant role in this determination. I have identified several examples in my testimony where I believe SCE&G management was inadequate and could have improved. Among the areas identified were delays in rectifying the lack of production and poor quality of the production of structural modules by the Lake Charles facility. Also, delays in developing a resource-loaded integrated project schedule. This was consistently and constantly pursued by ORS and never came to pass. And lastly, the failure to hold the contractors accountable for improving productivity and failures and delays to implement processes and programs that would have improved productivity. These are only a few examples of SCNG's poor management of the project. However, the company's major failure, and the one that should void and prevent their attempt to recover all the abandoned costs of these units, is their intentional and material misrepresentations, omissions, and deception that they perpetrated on the PSC, ORS, and SCE&G customers. This concludes my summary.
Mr. Chairman, Mr. Jones is available for cross-examination by the parties and questions from the commissioners, if any.
Okay, we're not going to call the roll. We'll ask for cross.
Mr. Chairman, I have one preliminary matter I'd like to raise for the commission. I'm John Challey with SCE&G. I want to make clear for the record, Mr. Jones is here purportedly as an expert, but he's not testifying as an expert at all. He's acting as a finder of fact. He is repeating what he claims he learned from an isolated set of facts that he says he reviewed. There are significant disputes as to these facts. We believe Mr. Jones is wrong. But in any event, it's not the job of Mr. Jones to decide these disputed issues of fact. It's the job of the commission to do that. Now, while we're prepared to cross-examine Mr. Jones and to continue with his testimony, we want to make clear our objection to Mr. Jones's testimony in this regard. And as Mr. Ziegler did yesterday, we would request the ability to maintain a standing objection to Mr. Jones's testimony on the grounds that I just described.
Okay, thank you. Your objection is overruled. Okay, Mr. Knapp.
Mr. Chairman, may I just inquire about the expected order of cross-examination? I just assumed I was coming up first, but that was my mistake.
Well, could have been my mistake, but you can go next. Is that okay, or you want to go first?
It's at the commission's pleasure, Mr. Chairman.
Okay, go ahead. Mr. Knapp says.
Morning, Ms. Jones.
Morning.
I think you and both the chair observed that both of us are somewhat long in the tooth on these matters. I don't know that that others have been made aware, but you and I had occasion to cross paths south of Chicago, Illinois, in about the 1986 timeframe, did we not?
Yes, sir. Yes, sir.
I represented a public interest group challenging the NRC license for the Commonwealth Edison Braidwood nuclear facility, and you, as a Sergeant and Lundy senior engineer, were involved in the construction of that project. Isn't that right?
Yes, I was actually Sergeant Lundy's project manager for that project.
And we had a long and spirited case, but I think I've expressed to you, and I want to repeat for this record, that I have great respect for those who seek to build these extraordinary machines right. And you'd agree with me, wouldn't you, that because of the complexity and the important safety concerns that are involved in a safe design, construction, operation of a nuclear plant, that adherence to standards of quality is essential, correct?
Yes, I would agree with that.
You familiar with the NRC's Part 10 CFR Appendix B, Part 50 Appendix B, quality assurance standards?
Yes.
And those quality assurance standards that were applicable in the 1980s timeframe when we were together in Illinois remain the benchmark of the quality requirements for building a nuclear plant today, don't they?
Yes.
Would you agree with me that essential to meeting the NRC's quality standards is that you adhere to a rigid system of honestly reporting non-compliances and defects as you encounter them in the course of construction?
That is especially true to the NRC and part of federal regulations that be done, yes.
So, in essence, you as the owner or the constructor or the craft building the plant are expected to honestly report on observed conditions, to document any failures to meet standards, and to see that those failures are timely corrected in order to assure that the plant is constructed as designed.
Yes.
Those standards are particularly important when we're talking about systems that are critical to the safe functioning of the plant, safety system, correct?
Yes.
So, for example, if someone were to falsify an inspection record of welding on a safety-related system, that would be fundamentally at odds with the quality assurance standards expected of the NRC and of federal law in building a nuclear plant.
Yes, that is against the law.
And even though the NRC can only perform an audit inspection, they depend on the constructor and the owner to have a system of integrity themselves for honestly reporting on the conditions that they observe in the field and seeing that any problems are corrected before the plant is in operation. Fair enough?
Yes, the NRC relies on the first line of defense is for the licensee or the owner to have a good reporting system.
Can we agree that the practice of deliberately falsifying quality records, say in quality control inspection reports, that would be at odds with the expectation for properly constructing a nuclear plant?
Yes.
Likewise, misleading an inspector, an NRC inspector, about the quality of a plant, that would violate federal law and be at odds with the standards expected, wouldn't it?
Yes.
In your long career, you adhered to those sets of standards and those sets of expectations, ensuring that a nuclear plant was built properly.
Yes, sir.
Now, building a nuclear plant at that level of quality comes at a cost, does it not?
Yes.
And that, what I mean by that is unlike building perhaps a photovoltaic utility scale solar farm, we're not concerned about that means of generating electricity causing a catastrophic accident that would require adhering to the same level of quality standards. Is that a fair statement?
There are specific safety standards that apply to nuclear power plants that don't apply to other power facilities, yes.
And that higher level of quality associated with the safety considerations comes at a price.
Yes, it does.
Let's turn, if I could have Ms. Wheat's help, I'm going to try to use the overhead here, the Elmo. While we're doing that, if you could turn in your direct testimony to page 15, I want to direct your attention to what you say there. Have that?
All right, sir.
Beginning on about line 9, middle of that page, you're talking about substantial completion dates information that SC&G was either withholding or not providing to ORS and Commission. Did you see that? We direct you to line 10. I have concluded that this continued withholding of the schedule was a deliberate attempt by SC&G to mislead the PSC and ORS about the true completion dates of the project and to provide new dates for the sole purpose of gaining approval of subsequent revised rate increases, approximately $65 million, that followed once the revised substantial completion dates and associated BLRA milestone schedules provided to the PSC. Do you see that testimony?
Yes.
Now, that relates to the I believe you call it the EAC, the project completion committee that Carlette Walker chaired. Is that correct?
Well, the EAC committee dealt with project costs, not specifically with project schedule.
Cost driven by that schedule.
Actually, the cost that the EAC developed was not. It was cost based on the schedule that was provided by the consortium. Yes, and in the filing.
You characterize that information provided by SC&G as a deliberate attempt by SC&G to mislead the PSC and ORS. That's your testimony, isn't it?
Yes.
Let me direct your attention to now the public non-redacted version of your surrebuttal testimony. Do you have that available to you?
Just a moment.
And page 3 of that.
Sorry. All right.
Mr. Chairman, I'm Elmo, and if I can add now this excerpt that has now been made public relates to that EAC committee's determination and how that information was communicated for us. This now public version of your surrebuttal testimony that we're directing your attention to relates to that same question of reporting of the results of the EAC committee's work, translating a completion date projection into a project completion cost for submission to this commission, correct?
Yes.
Right. Would you read the highlighted portions, actually begin at the beginning of the sentence, but then read the highlighted portions that are now been made public of your surrebuttal testimony?
You're talking about begin on page 49?
I'm talking about your surrebuttal testimony, the one that's on the screen now.
No, that's the beginning of the sentence I'm talking about.
Yes, that's fine. Thank you.
Okay. On page 49 of the transcript, lines 7 through 10, Ms. Walker discusses the pressure exerted by Kevin Marsh, Steve Byrne, and Jimmy Addison to get her to lie about the estimated cost of complete VCS 2 and 3 in preparation for her direct testimony associated with the March 12, 2015 filing under Docket 2015-103E. Continue?
Yes, please.
Based on my reading of the transcript of her deposition, it is clear she and her team had prepared a cost estimate that established a cost increase of $1.2 billion rather than the $698 million. And see pages 54, lines 20 through 22 of the transcript. That SC&G had included in their filing in docket number 2015-103-E. Ms. Walker indicates that she tried for 4 months prior to the PSC hearing to convince the SCE&G executives to use the cost to complete she and her team had developed, but to no avail. See pages 49 and 50 of the transcript. Ms. Walker then states that SCE&G then filed false testimony under her name, page 51 of the transcript.
I'm going to get you to turn, please, to the next page and read the next redaction that has been now released.
Okay. You're talking about page 4, beginning on line 8?
Yellowed highlighted text, yes.
You just want me to read the yellow highlighted text?
Or the beginning of the sentence to make it clear.
Okay, that's for the beginning of the sentences. Okay. Mr. Brown worked for SC&G from November 2009 until July 2016, in the Business and Finance Group at the VC Summer 2 and 3 site under the supervision of Mr. Abney Smith. I'm sorry, there was a closer one. On page 19, line 14 of the transcript, Mr. Brown states that Kevin Marsh, Steve Burns, and Jimmy Addison were, quote, not being truthful, end quote, and further clarifies in line 18 that, quote, I don't believe they were truthful about the status of the project and multiple quarterly reports and filings, end quote. Continue?
Please continue.
Okay. On page 95 of the transcript, Mr. Brown discusses the SCE&G team formed in August of 2014. Mr. Brown goes on to state on page 101, lines 6 and 7 of the transcript that, quote, our conclusion was that CB&I had underestimated the cost in a number of categories, end quote. He indicates that the EAC team developed their own estimate, and he corroborates the cost values provided by Ms. Walker in her deposition. In addition, Mr. Brown states on page 209, lines 3 and 4 of the transcript, that the EAC presented their results to the SCE&G executives on October 13, 2014, and that no action was taken to include their estimate, and the decision was made to file the March 12, 2015 petition with the consortium cost with which the EAC team disagreed.
And the now released redactions continue on to the next page. Would you read?
He further acknowledges on page 238, lines 2 through 7 of the transcript, that the EAC team work was not shared with the ORS. Only the contractor's cost estimate was provided. Continue.
Yes, yes, please.
Of interest in the transcript of the deposition is the reason provided to Mr. Brown for why SC&G did not present the EAC team's cost estimate was that this would have created an unlawful contingency on the project that could not have been accepted by the PSC. See page 77, lines 17 through 25 of the transcript.
And the next redaction, please.
On pages 147 and 148 of the transcript, he states, quote, and at least I did not, and I am sure Kevin, and he's referring to Mr. Kokums, did not either believe that it was an achievable schedule, end quote.
Thank you. Now, Mr. Brown, in his deposition, says that that conduct by SCE&G management was, quote, not being truthful, close quote. Page 4, line 11 of your rebuttal testimony. And indeed, Ms. Carlette Walker says flat out that SCE&G management lied to ORS, to this commission, and to the public. Do you believe, Mr. Jones, that SCE&G lied to you?
Yes.
And Mr. Jones, if they lied to you beginning in 2014, as you've testified, or provided misleading and false information, however you want to characterize it, is it possible that they lied to you and ORS and this commission earlier than 2014 about the financial health and completion dates for this project?
Mr. Gall, I would say that they did not. I don't have direct evidence that they lied to me in 2014. I have direct evidence that they withheld information in 2014. The lies, in my opinion, began with the filing when they totally misrepresented the schedule and the cost. I also have no evidence at this time that they lied to me prior to those dates.
Or let's call it misleading then in your terms. Withholding information is misleading. When you take an oath to testify as a witness, you swear to tell the truth, the whole truth, and nothing but the truth. So nothing but the truth encompasses the concept of withholding information. That's a lie as well as an outright falsehood, isn't it?
In the context that you put it under oath, yes.
Moment, Your Honor. Now, my expert, Dr. Mark Cooper, cited several documents that predate the 2015 timeframe that were obtained through the discovery process in this case. And these are documents I think that you're familiar with and reference in your own testimony. Are you familiar with, for example, the September 5th, 2013 email that Mr. Marsh sent to WEC and the consortium regarding concerns about progress on the project? Your exhibit 2.4.
My exhibit 2.4. Okay, if you specifically quote that, then I would say yes. I don't have them all memorized by date and who sent what to whom.
This is that document, but it's identified and in the record independently as Dr. Cooper's exhibit MNC 6. That is the same document, is it not? An email authored by the former CEO of SCG, Kevin Marsh. You included that as one of your exhibits, namely exhibit 2.4, correct?
I would need to look, but if that is actually my exhibit, then yes. But I can't say that from just seeing it here.
Subject to check for the actual number. Do you recognize that email as a document that you obtained and reviewed in discovery?
Yes.
Now, Kevin Marsh to Lonnie Carter, Steve Byrne. I'm sorry, from Kevin Marsh to Westinghouse, copied to Lonnie Carter, Steve Byrne, and others, including Jimmy Addison. Dear Danny and Phil, I requested a meeting with both of you 2 weeks ago to discuss the status of our nuclear project. Again, this is written September 5, 2013. We and our partner, Santee Cooper, continue to have serious concerns about the consortium's ability to deliver modules from the Lake Charles facility. Consortium is now in its third year of unsuccessful attempts to resolve its manufacturing problems at the facility, which continue to impact our project negatively, and it goes on. Now, when did you obtain a copy of such of this document, this email? Was it before the abandonment of this project, Mr. Jones?
I cannot state definitively whether I saw this before abandonment or not, but I can state that I was familiar with the issues involved there. I was familiar with the issues.
But you can't state whether you saw this email or not.
I cannot. I don't recall specifically.
Let me show you then a document that's been received independently in evidence as Dr. Cooper's exhibit MNC 7, and I believe that represent that it's been identified as your exhibit, Jones exhibit 2.10. You recognize this letter? This is a letter from the CEOs, Mr. Marsh for SCANA and Mr. Carter for Santee Cooper to the Westinghouse Consortium.
If you could reveal more of it, I would appreciate it. Slide it up. No, I'm talking about the text. Again, I don't recall them specifically by date and by...
You read that? I can hand you the document.
No, I can see that. Okay, yes. Again, I can't attest to what number it was, but I think this is part of my testimony too.
And was that document, that letter, bearing a date of May 6, 2014, CEOs Marsh and Carter to the WEC consortium, was that document made available to you and ORS at the time?
Again, I cannot state definitively whether I saw that letter at that time or not. My best recollection is that we did not, because we usually did not see a lot of internal correspondence between the CEOs, but I can't state definitively that I did or did not see it.
Second page of that letter, second paragraph reads this as follows. The events since May 23rd, 2008 have tested our resolve. Now that would be the date of signing of the EPC contract.
Yes, I believe that's correct.
In this letter, we will review certain of those events for the benefit of your current management. We believe that such a review is called for because of the many turnovers in your management since May 23rd, 2008. Again, the point of this lengthy communique is to summarize the status of problems at the site in communication between SCE&G and Westinghouse. And as you sit here today, you don't know whether or not SCE&G provided this correspondence to ORS for its review at the time.
Right. I don't recall that, no.
Jones, let's look at your direct testimony, please. I want to draw your attention to page 6.
Right. Okay.
Moment, please. Page 6, line 22. The project was beset by unexpected problems and delays from the beginning. That's your testimony.
Yes.
Many of these problems are delineated in the May 6, 2014 joint letter from SCE&G's, next page, and the South Carolina Public Service Authority, Santee Cooper, known collectively hereafter as the owners, CEOs Kevin Marsh and Lonnie Carter, to the consortium CEOs Philip Asherman and Danny Roderick, Exhibit GCJ 2.10. The COL was delayed by 9 months. I'm going to read, but that's the same letter we just discussed, is it not?
It appears to be so, yes.
All right. And you tick off a number of issues that are reflected in that letter that you note supporting the observation that you just made. The project was beset by unexpected problems and delays from the beginning. Again, at that date, the CEO's letter recites, and you summarize, the COL issuance was delayed by 9 months and was not issued until March 30, 2012, versus the original schedule, July 1, 2011. That's a statement you make, yes?
Yes.
The start of the first nuclear concrete pour of the nuclear island, NI, foundation on Unit 2 occurred on March 9, 2013, rather than the scheduled date of August 24, 2012. That was a delay. You referenced that based on that letter, correct?
Yes.
This date was significant because it marked the start date of Nuclear Island, or NI, construction, and the time when critical path construction activities could begin. Any problems with equipment or component delays or failure to meet construction schedules after the start of NI construction would potentially be impactful to the completion date of the units. That's your testimony.
Yes.
Page 7, line 12. Also, line 11. Also, the WEC design, WEC, Westinghouse Electric Company, design was not as complete as advertised and had not been properly reviewed for constructability by the consortium or SCE&G. That's your testimony?
Yes.
Going further, the module fabrication facilities promoted by Shaw to be state-of-the-art industrial complexes failed to achieve both quality and productivity, resulting in significant project delays. That's your testimony?
Yes.
Those problems at Lake Charles began from the very outset of their work on the module fabrication, did they not?
Yes, that's correct.
Did those problems at Lake Charles include the falsification of inspection reports required by the Nuclear Regulatory Commission?
Those were the findings of the NRC and were reported in inspection reports by the NRC, yes.
And did they characterize those series of events as representing a breakdown in the quality assurance program at the Lake Charles facility?
They were characterized as such in the NRC reports, yes.
And the term of art, breakdown in the quality assurance program, that represents a fundamental failure to meet NRC requirements requiring major corrective action. Isn't that true?
I would generally agree with that characterization, yes.
Reading further, line 14, same page. The new licensing regime proved to be as obstructive and intrusive as the old, if not more so, engendering delays and increasing costs. Now, the new licensing regime is the combined operating license approach that replaced a two-tiered approach from the 80s era where you got a construction permit. Once you built the plant according to that permit, you then sought and got an operating license. That's the old regime, correct?
Yes.
The new regime combined both of those steps into a single step.
Yes.
But it also involves significant reliance on the constructor, owner, demonstrating at the end of the construction process that they had actually constructed the plant in accordance with an approved design. Isn't that correct?
Yes. There's a general phrase in the old regime is Part 50, and that basically it's characterized as you had to license what you constructed. The new regime was Part 52, and it's characterized as you had to construct what you licensed.
And the new approach really depended even more so on the integrity and effectiveness of the owner-constructor to ultimately demonstrate to the NRC's satisfaction that the as-built condition of the plant met minimum design standards. Isn't that correct?
Yes.
And doesn't that involve, among other things, the ITAC process, if I'm using the acronym properly?
Yes.
Tell the commission just what that stands for, if you can remember the acronym.
I always have trouble with this, but I can characterize what it is. The NRC established criteria that in order to establish that you in fact have built what you said you were going to build, they required that you submit essentially, for lack of a better term, a certification. And those were ITACs, and it's has to do with acceptance criteria, and I'm sorry, I can never remember this acronym for some reason, but the characterization is there that you had to submit these specific reports that attested that you built the plant in accordance with your licensing basis.
And can we agree in shorthand, Mr. Jones, that SCE&G and WEC Consortium were way behind the 8 ball in their ITACs, way behind in being able to justify the as-built ongoing condition of the plant as meeting the NRC's design requirements, or the design requirements that they were expected to meet?
Mr. Gall, I think what I can say there is they had many, many more ITACs that they had to submit, and the time frame in which they had to submit that grew more and more compressed, which brought into serious doubt both their ability to do that and then the NRC's ability to meet that. Now, there were many meetings on this topic with the NRC, and the NRC insisted that, in fact, they could meet the schedule as worked out finally with SCE&G. But it was going to be a massive task. There's no doubt about that.
Right, sir. Well, I just drew perhaps the unfair implication from that last sentence that we read. That is, the new licensing regime proved to be as obstructive and intrusive as the old, if not more so. It sort of suggests that it was the NRC's fault wholly that this new regime didn't work. But some of the blame, if not most of the blame, falls on WEC and the owner. They had the obligation of making this new system work through, say, the ITAC process, did they not?
Yes, that is true.
Last sentence in that same paragraph, again, page 7, line 16. The EPC contracting approach appeared to be driven more by cost reduction concerns than by quality and productivity, and created deep animosity among the consortium partners and the owners. Now, we all, of course, are glad to hear about cost reduction, but when you say cost reduction, what are you referring to in that sentence?
I think maybe the best thing I can do is give some examples. And in the up until near the end of the project, the Westinghouse approach, and that foisted on their contractors was to do a just-in-time delivery of various commodities. And by commodities, I mean things like rebar, embedment plate, bolts. So all these things, they would wait until the last minute to order them. And this oftentimes resulted in delays of construction activities. In the latter stages of the project, really in the time frame when Fluor came on board and when some of the Bechtel recommendations were implemented, these the programs were set up to correct some of these. But this is, in general, what I meant. There was a great deal of animosity between WEC and, Westinghouse and CB&I. And in fact, as reported in several of the meetings which we found, meeting notes which I found during discovery, the Westinghouse CEO and the CB&I CEO would not even be in the same room together.
Was that information you knew at the time?
No. We knew there was a lot of animosity, and most of it was driven by commercial concerns, that things that CB&I maintained should have been changes and cost increases Westinghouse was refusing to pay for. So that stuff we knew, but we weren't really aware that the CEOs wouldn't even be in the same room together.
Page 7, continuing again your direct testimony, line 19.
Counsel, excuse me for interrupting, but we have read this testimony. It is a part of our record, and could you try and finish up, because we, with all due respect, it seems like we seem to be dragging a little bit.
Happy to.
Thank you.
Among other important and most potentially impactful events that occurred on the project, line 19, page 7, are the changes in the consortium partners responsible for construction. The first of these changes occurred on July 12th when Chicago Bridge and Iron CB&I announced their intention to acquire Shaw and assume the construction contractor's role in the project consortium, and it goes on. And that was July of 2012 that change took place that caused problems with the project, correct?
When you say cause problems, I mean, it was viewed at the time as a welcome change. And usually transition between construction contractors, in my experience, take between 3 and 6 months before the new contractor is fully functional. That doesn't mean he's not doing anything. But before he gets his programs implemented and before he starts to make a real impact on the project, usually takes 3 to 6 months. So, as I say, at the time, CB&I was a respected contractor in fabrication of large pressure vessels, and at the time, the bringing CB&I on board was viewed as positive.
And at that time, you were hopeful that they could turn the project around.
Yes, I was hopeful that they would be part of turning the project around and getting things done.
But in short, and to cut to the chase, if SCE&G was lying to you in the 2015 timeframe and misleading you in the 2014 timeframe, why on earth would you not have expected them to be misleading you and potentially lying to you even earlier in the project?
Mr. Gall, I don't know how I can apply retroactive thoughts. I knew what I knew at the time, and in 2012, if you're taking that as an example, as I said, we viewed this as a positive change.
Well, I believe in each of your subsequent your iterations of your testimony, you said, I'm testifying based on what I know at this time, with many disputed discovery matters remaining outstanding, and my testimony is subject to change and amendment, including going back even earlier in time, if I learned through the discovery process of more evidence of false, misleading, or inaccurate information submitted by the company to ORS. Correct?
That is correct, but I did not find any in my review of the discovery process that took me back before March 12, 2015.
Last, in your summary, page 11 of 12, line 14, I do reserve the right, however, to supplement or change my opinion based on additional information that may become available through ongoing discovery. You said that today, November 2nd, while the hearing is ongoing, correct?
Yes, sir.
All I have. Thank you very much.
Thank you. Thank you, Mr. Knapp.
Mr. Jones, good morning, sir.
Good morning.
Thank you for all your detailed testimony, sir, rebuttal testimony, and your response to Mr. Gall. And within all of that, I imagine I can surmise the answer to my question. But I would like to have a succinct response based on your factual knowledge. In his opening remarks, Mr. Balzer, counsel for SCE&G, has said that ORS knew everything about this nuclear project. Now, if this assertion is correct, follows that to the degree that the PSC did not receive all the vital information they needed over the years that ORS was complicit in this deception. So, Mr. Jones, did you, because you were an integral part of the ORS team, did you know everything that SC&G knew about this nuclear project before it was abandoned?
Absolutely not.
To your knowledge, did ORS know everything about this project prior to abandonment?
No.
Thank you very much.
Thank you. Any other parties? Ellerby.
Thank you, Mr. Chairman. This should be short. I got the message. Frank Ellerby for Central Electric Cooperative and the Electric Cooperatives. Mr. Jones, I have a few questions for you, please, sir. And I've got one of your exhibits to ask you about, and I want to get the context. The filing that was made by SC&G in 2015 that you've talked about, which was, I think, Docket 2015-1003E, which was an update filing in which the company asked the Commission to approve updated cost estimates and schedule, and an updated schedule. Is that right, sir?
Yes.
Okay. Am I correct that that filing, the numbers, the cost numbers and the schedule numbers in that filing were based on information that was prepared by the consortium and provided to the owners in 2014?
From all available records that I've got, that is the case. There are documented reviews that were done by SCE&G, but it's basically what the consortium prepared.
And that was that you anticipated my next question was there was a review of the information that was prepared and provided by the consortium, and the company reviewed that information. Is that right?
Yes.
And I think you talked about that review that first of all the information prepared by the consortium was known as the EAC, Estimate at Completion. Is that correct, sir?
I believe it was also referred, it may have been ETC. I'm not sure. The EAC primarily, in my testimony, refers to the EAC team of SCE&G.
Okay. And wasn't the EAC team of SCE&G the team that was assigned to review the consortium's estimate at completion?
Yes.
Okay. And that the review team is the team that was led by Ms. Walker, and Ken Brown was on that team also.
Yes.
And you've described their testimony. Is that right, sir?
Yes, I've used some of their testimony. I've reviewed their testimony, and some of it I've utilized in my testimony. And
I have a document. This is ORS Exhibit GCJ 2.24, and I'm going to try to hand out copies to appropriate counsel and to the Commission. Are you familiar with this document, Mr.
Yes.
Jones?
Yes, I obtained this document during discovery.
What is the document, please, sir?
It's basically an email from Mr. Michael Crosby to Steve Byrne, and it provides them with some projections worked up under Mr. Crosby's direction about what the cost and schedule are going to be for the unit.
First of all, who is Michael Crosby?
I don't remember his exact, I think he's Vice President of Nuclear for Santee Cooper, but I'm not sure of his exact title, but he's an executive at Santee Cooper.
Okay. And do you see the, you mentioned that the email was sent to Steve Byrne. Do you see the CCs, Jeff Archie and Marion Cherry?
Yes.
Can you identify Mr. Archie and Mr. Cherry, please?
Again, I don't exactly remember Mr. Archie's, Mr. Archie's title. I think he's Chief Nuclear Officer for SCENG, SCENG, but he's also a senior executive at SCENG, that I know. And Mr. Cherry was the on-site representative for Santee Cooper. Don't know what his exact title was, but he was the on-site representative at the plant.
Isn't it correct that Mr. Cherry was involved in the review of the consortium's schedule information and cost information that was produced in 2014?
I believe in some of the documentation that I've seen, Mr. Cherry was listed as an attendee, but that is not really what I know is what's listed on the documents. I don't know any additional information about his participation.
Do you recall reading Ken Brown's deposition on that subject?
On the subject of the EAC?
On the subject of Mr. Cherry's involvement in the schedule review in particular?
I don't remember that specifically, no.
Right. Let me ask you about, actually, I've got better copies. Mr. Chairman, there are three. This document is already into evidence, so I'm not going to ask that it be put in again. There are three pages following the front page, and I have color copies of that. It's a document that was produced to us separately, and I'd like to hand those out. They're a little bit easier to follow. Mr. Jones, can you identify the pages that I just handed you?
Yes, these appear to be the same pages that were attached to the email we were just talking about.
And, Mr. Chairman, I'd like to, just for the record, the only difference that we've been able to ascertain is this version, the color version, has a stamp on it, confidential Santee Cooper internal use only. That confidentiality, claim of confidentiality has been withdrawn, as we understand. The document has been produced in various iterations and was produced to us in discovery. There is no Bates number. I am told that's because it was produced in native format, and I do not know what that means, but that is the explanation for why there is no Bates number on it. I'd like to offer this as the next hearing exhibit.
It'll be exhibit number 17.
Mr. Jones, let's go through these pages, please, on exhibit 17.
Okay.
Okay. You see the first page. What is in these categories the table? Let me use the Elmo. The yellow line has 3 columns. What is PF, sir?
That I am pretty certain that refers to productivity factor.
Okay. And the next column, IC-DC ratio. Do you know what that is? And you're welcome to refer back to Mr. Crosby's email where he explains what these things
I see it now. It's the indirect to direct craft ratio.
Okay. And then the third column, what is FNM/DC ratio?
That's the ratio of the field non-manual to direct craft.
Looking down to entitlement, the final one, what is entitlement for those numbers, please? Do you know what entitlement is?
Not directly in this context. They usually talk, well, I shouldn't say.
Okay. Do you know what EAC is in this context?
It should be the same as we've talked about, which is estimated completion.
Okay. And the PF for the EAC is 1.15. Do you know whether, Mr. Jones, that is the number that the consortium used for a productivity factor when they prepared their EAC, their estimate at completion?
That was my understanding, that was the productivity factor that was utilized.
Okay. And would you agree with me that if we compare that number, the estimate at completion number of 1.15, to the yellow line, the yellow information, that the PF of 2.27 for the time period of September 14 through January 15, that the consortium had significantly worse productivity than had been used in coming up with the EAC. Is that correct, sir?
Yes.
All right. If we look at the next column, which is the indirect to direct craft labor, the ICDC, you agree with me that the EAC that was used by the consortium is 0.39 as compared to the actual experience during the time period September 14 through January 15 of 1.31. Do you see that, sir?
Yes.
And am I correct that that's significantly worse performance in terms of cost and moving the project towards completion than what the consortium had used in its EAC?
I would agree that it's a significant ratio relative to cost. Relative to completion, it doesn't really have that much impact. It strictly drives cost.
Okay, very good. And then the next column, again, we have a for the field non-manual to direct craft ratio used in the EAC of 0.53. And the actual experience in the time period immediately following the consortium providing the EAC, the actual experience on that measurement was 1.25. Again, significantly higher.
Yes.
And the lines show these various that these different scenarios, as Mr. Crosby provided them to Mr. Byrne, show that the various scenarios, the impact on cost of these various scenarios relating to these ratios. Do you see that, sir?
Yes.
And do you understand that all of these measurements, these things that Mr. Crosby was pointing out and singling out in his email to Mr. Byrne, have an impact on the cost?
Yes.
Do you do you see in going back to the email from Mr. Crosby? I could direct your attention to this paragraph right here. Kind of in the middle of the body of the.
Okay.
Okay. Mr. Crosby says that the reason that he had not provided a curve that was based on the numbers that the consortium actually achieved during the period September 14 through January 15 is that, and to quote Mr. Crosby, a total target cost curve for this data is not shown on the graph because it would be off the chart. Do you see that, sir?
I do see that.
If we can turn to the next page of the color copy, I think these are simply additional information. You see the green line down at the bottom?
Yes.
Is that, do you understand that to be the EAC basis, which was the number that the consortium used in doing its calculation of the EAC? You see that, sir?
Yes, I mean that's what it's purported to be. Yes.
Okay, and you see the plotted numbers, points above that are the actual months for on the first line is direct craft productivity as compared with what the consortium used. You see that, sir?
Yes.
Okay, and then the same thing for the next two depictions. The company, and this just reaffirms what you and I discussed on the first page, the actual performance during the period September through January, immediately after the consortium provided the EAC to the owners, the actual performance of what was going on out there and these metrics was significantly worse than the consortium had used. You see that, sir?
Yes.
Turn with me to the next page, the last page of Exhibit 17, please. Do you see this depiction? And this, I believe, relates to schedule of the completion of the project, doesn't it, Mr. Jones?
Yes.
As I understand this, the blue dotted line graphs out what it's simply an extrapolation of the progress on the project to date. And if you do that, if you simply assume that the company would continue at its level of progress that had been achieved through January of 2015, where would the company be, according to this document, in July of 2019?
At roughly 30%, according to this.
30% completion of the project?
Yes.
Okay. And am I correct that the green line would be, the green dotted line going up is the improvement in productivity that the company would have to achieve in order to get the project finished by January of 2019.
That's what it is supposed to represent, yes.
I know it's here somewhere. Mr. Jones, was the project proceeding in 2014 and 2015? Was the plant being constructed within the parameters of the approved construction schedule, the construction schedule approved by this commission?
You're talking about was it being constructed in a time that would have completed the project by the cost and schedule that was in place at that time?
I want to ask you about the schedule and cost estimate that had been in place prior to the 2015 filing, and then the same question on the new cost and schedule that was approved in Docket 2015-103. So first question is, as to the cost and schedule that was in effect in 2014 and the first half of 2015, was the project being constructed at that time within the parameters of the approved cost estimate and schedule?
No, it was not, and that really is the reason that prompted the filing to change the projected construction schedule and the budget.
And after that change was approved by this commission, was the project then, at that time, being constructed in a manner that was consistent with the new approved schedule and a cost estimate?
No, unfortunately, it was not. The expected improvements in productivity really were never manifested on the project. So the goals that at the time we thought were going to be met were not met, and it continued to lag the productivity factors that were required and the monthly production that was required.
Did the consortium, Mr. Jones, at the time that the EAC was provided, did the consortium promise that it was going to make improvements?
If promise means that did they state that it was going to be met, that they thought that this was a viable schedule, and that they supported and agreed to, then yes.
Let me take you back to Mr. Crosby's email again, please. You see if you could find the paragraph I'm pointing to now.
All right.
Mr. Crosby says, as you recall, upon receiving the EAC August 2014, the consortium promised to self-correct and drive productivity and the labor ratios back closer to the EPC basis. You see that, sir?
Yes.
Isn't it true, though, that we've just seen from these documents that Mr. Crosby had prepared that the consortium actually, instead of improving those ratios and improving productivity, went the other way, that it deteriorated, that it got worse?
I think that's a fair characterization, yes.
Okay. Thank you, sir. Nothing further.
Okay, any other cross from parties?
Good morning. John Kaufman, representing AARP. How are you doing, Mr. Jones?
Good morning, sir.
Let me first ask you, are you aware of AARP's testimony filing this case? Did you review Scott Rubin's testimony?
Yes, I did.
And you're aware that he has a different recommendation regarding the cutoff date for when that the evidence became so compelling as to be imprudent?
Yes, I am.
And you recall what that was?
Not off the top of my head, no. I just know it was earlier than what we're saying.
Let me get my. Mr. Gile covered a lot of the ground I was going to cover. I just have one particular line of questions I have for you. To be clear, one of the factors that influences your March 2015 cutoff date was the failure of SCE&G to disclose the hiring of Bechtel, as well as the failure to disclose the findings made about the progress of by Bechtel.
Yes, sir.
And on page 9 of your direct testimony, you state that SCE&G was aware in early 2014 that the project needed an independent comprehensive assessment of the construction status, schedule, and budget, but withheld those plans from the PSC and the ORS. Is that fair characterization of your testimony?
I'm sorry, would you cite your reference again, please?
Page 9, line 22. Over into page 10.
Okay, yes.
And when you say they're early 2014, are you referring to the May 2014 date that you refer later in your testimony based on when Mr. Marsh began discussions about engaging an outside expert to evaluate the construction progress schedule and cost?
Yeah, that's generally the case. That was the first evidence that we were able to find, or the first citation we were able to find that they were considering this.
And Mr. Marsh is the CEO of SCANA, SCE&G's parent company.
He was at the time.
And when you go on to describe that in September 2014, Mr. Marsh indicated they were ready to retain an outside expert to look at the cost, and that they ultimately retained Bechtel Power Corporation in about August 2015. Am I right?
I think that's when Bechtel started their assessment. I think the contract was initiated before that, but I think August is the correct time frame.
Okay. In your expert opinion, given all the knowledge you have of this project, do you think it was prudent for SCE&G to wait until August 2015 to actually engage that?
No, sir.
Wouldn't a reasonable and prudent utility in the position that SCE&G was in May 2014 retain an outside expert to evaluate construction project schedule and cost ASAP?
Okay. Let me just say I think I misunderstood your date. I thought you were citing the August 2015 date.
Well,
at that time, when you said, did they wait too long? The answer in that case would be yes. Relative to the question on imprudency before that date, do I believe that they should have had someone on board as an independent engineer? In my opinion, yes. Did it at that time constitute a complete lack of imprudency? Debatable.
Okay. Would you say it is relevant evidence to the question of prudency? How long they took?
Again, my major concern is how long it took them from the time they decided to do it until they did it, rather than from the time of the inception of the project. But I have no qualms with stating they took too long to do it once they decided to do it. I have no issues with stating that.
Do you understand that the South Carolina definition of prudence includes the concept of being timely?
I understand that, yes.
Okay. Do you know why SCE&G decided to retain an expert in August 2015 rather than some earlier point in time?
All I can say is what from the record that I now have, they were being pressured by their partner, Santee Cooper, pretty strongly.
So to be clear, was it September 2014 when they were internally saying that they were ready to engage an outside expert?
Yes, that's a time they actually, I believe, had meetings that indicated that, yes.
And they still waited 11 months to actually engage Bechtel, correct?
Yes, and I would just like to state that the reason I believe that delay was unacceptable is because they had a petition pending before the PSC. There was no reason for them to wait that long to do that. There was no reason for them to withhold that information from the PSC. That should have been done in a timely manner to support or refute their petition. In fact, it should have been done. The notification should have been done before that, and the petition should not even have been filed until they completed that review.
Now, I want to ask you, if in fact SCE&G had actually been told by experts in the nuclear industry that they should have hired an outside expert as early as the summer of 2013. In that situation, would it have been prudent for the utility to wait until August 2015, almost 2 years later, to hire an expert?
Again, we're getting into an area that of the imprudency that is I'm sticking to my date. March 12, 2015 is when I believe imprudency began. Would it have been a good idea? Would it have been good practice? Yes. And in fact, my first meeting with on the site, and you can't document this, so my first question to them was, why don't you guys have an owner's engineer? And basic response was, we don't need one. We know what we're doing. I brought this up several times through discussions when things weren't going well. So I advised them repeatedly throughout the project that they need an owner's engineer or somebody to do an assessment of the project.
Do you recall how early in time you made that recommendation for an owner's engineer?
Well, yeah, it was at the first meeting I had with them. That was either, I'm not sure I met with them in August, but it was September of 2011.
Mr. Jones, are you familiar with the Institute of Nuclear Power Operations, INPO?
Yes, I am.
Can you briefly describe what you know about INPO?
Well, INPO is an industry organization that was actually formed after TMI, and it basically addresses, it's a
3 Mile Island?
Yeah, I'm sorry. After the 3 Mile Island accident. And it's basically an organization that, for the most part, addresses operational excellence for nuclear power plants. Their primary focus is on operation. They do offer some advice and counsel to plants under construction, but their primary focus is on nuclear plant operation.
So would you consider INPO to be consisting of recognized experts in the field of nuclear power plant operations and construction?
They certainly have recognized experts on their staff. I don't know I'd classify everyone as that, but yes, they do have recognized experts, and they draw from the industry for their to supplement their resources. So they have access to some of the best nuclear people in the world.
Are you aware that, and by INPO I mean INPO, are you aware that INPO conducted a construction review visit for the VC Summer Unit 2 and 3 in June of 2013?
I can't say that I was aware of that. I don't ever remember. I remember there were several INPO assessments that went on throughout the life of the project. The specific one I don't recall, but I know that INPO was there several times.
Are you aware that INPO issued a report after June of 2013 containing recommendations to the project owners?
I'm not aware of that, although it doesn't surprise me. That's what they usually do. But INPO reports only go to the utility.
Permission to show that it's an exhibit?
Yes.
Try to. Yes. Mr. Jones, have you seen this document before?
Actually, I saw it only this morning. I haven't seen it before this.
SC&G had not provided that document to you during all the time that you were reviewing their information. Is that right?
That is correct. And, I mean, as I said, that would not be beyond the realm of usual practice. It's usually only given to the utility.
Is this the kind of would this document have fallen within the scope of discovery that ORS sent to SC&G?
I can only give my opinion. I don't know what the legal aspects are, but in my opinion, yes, it should have fallen within that.
Can you briefly describe what this document is?
Well, from the cursory look at what it is, it's their letter that, as they always do, it's the letter that forwards the results of their visit, they call it, not an inspection, their visit to the BC Summer Station 2 and 3 during June 10th through the 14th, 2013.
And so they make recommendations regarding excellence in nuclear power plant construction. Is that fair? Or that's what they call it?
Well, I think if you actually look at this, most of the recommendations come toward the operational phase of the units, but there are some recommendations relative to construction, yes.
And do you agree that this July 2013 INPO report recommended that SCE&G take a series of actions to improve the monitoring and oversight of the project?
I did see that, yes.
And if I could turn you to page 13 of this document, and particularly recommendation item D. That recommendation that the project owner should retain an outside expert to evaluate construction progress.
Okay. Yes, I see that.
Okay. Do you understand that recommendation to include an evaluation of the likely schedule and cost project?
When you say the health of the construction phase of the project, yes, that would include schedule.
And would such an evaluation be the type of evaluation that Bechtel ultimately conducted?
In actual, I mean, this could be done in several ways. It could be done through a single inspection. It could be done through a ongoing effort by an outside firm. It could be done by well, no, I won't use that. But senior members of the industry coming in periodically, looking at the project. So there's several ways that this could have been implemented.
Are you aware that SCE&G engaged in any of such activities pursuant to that recommendation?
Not until
2015.
I would classify that the Bechtel assessment as that, and you could probably in the latter parts of the project, I wasn't going to mention, but now with the CORB, the Construction Oversight Review Board, which is CORB, C-O-R-B. They implemented that. Only had 2 meetings.
What time frame, sir?
My recollection is in the fall of 2016, I think.
But not during any of 2013 or 2014?
Not to my knowledge, no. I've seen nothing that indicates that they did anything along these lines.
In your expert opinion, would a reasonable and prudent utility in SCE&G's position in July 2013, having in its possession these INPO recommendations, have waited more than 2 years to retain an outside expert to evaluate construction progress, schedule, and cost?
Again, I can go as far as to say that it would have been good practice, and that these are the same recommendations that IMPO gives. They're good practice recommendations. It would have been good practice, and they should have done it.
And would it be fair for this commission to hold SCE&G to that high standard of acting swiftly when you receive a recommendation of an outside review? And not wait nearly 2 years to actually implement it?
Well, again, I would say it would be better if they'd done it on a more timely basis and implemented it earlier in the project, yes.
So would it be fair, is this report significant enough that it belongs in your timeline now that you're aware of it? We put that report in the 2013 timeline?
If you're asking me if I want to put it in there, the answer is no. As I said, there were several IMPO reports that happened throughout the life of the project. They had their own recommendations and things to do. And as I said before, I do not consider this where I have made the determination that imprudency begins.
And I understand that you're sticking with your date and that you're confident about that date. Would you agree that there are a plethora of facts in the evidentiary record here that might cause other experts to draw that line at an earlier time?
I have to concede that because I've heard that already.
Right. Your Honor, that concludes my cross-examination, but I would like to offer this into the record, this IMPO record report of July 2nd, 2013.
We'll enter it into the record as exhibit number 18.
Very much.
Okay, thank you. Okay, we're going to break now for lunch. We'll be back at 1:20.